Before I call my client, your worships, should that in fact be necessary, I wish to make a submission that there is no case to answer. You have heard no direct evidence from the Crown to confirm that the statutory warning was given to my client. You will be advised by your legal adviser that such a warning is mandatory under the Road Traffic Act. If the Crown cannot prove to the requisite standard that such a warning was given, then their case fails.
That is the case, ma'am, under Section 7.7 of the Road Traffic Act 1988.
Could we see the case management form, please?
Yes, ma'am.
Thank you. Am I right in thinking that this is the first time the issue has been raised?
That's certainly my understanding, ma'am. At the first hearing, when the defendant pleaded not guilty, the defence claimed that giving full details of their defence would infringe the defendant's legal professional privilege. And following a full exploration by your colleagues as to witness requirements, it was agreed that all prosecution evidence could be served under Section 9.
With respect, ma'am, it is not the duty of the defence to plug gaps in the Crown's case. The fact is the Crown has now closed its case. I fear the court will have no option but to dismiss the case, either by finding my client not guilty or there being no case to answer. I will clearly not be calling my client to give evidence in view of the fatal flaw in the Crown's case, which has been confirmed by your legal adviser.
Despite the fact that we have closed our case, there is authority to suggest that we can call further evidence with leave of the court and may have to seek an adjournment to do that if the police officer concerned is not available.
Well, that would certainly be my advice, ma'am, with authority provided by the oft-quoted case of Chorley Justices and a 2007 case on the point, Malcolm and the DPP, where in circumstances very similar to these, it was thought to be appropriate for evidence to be called after the magistrates had retired to consider their decision at the end of a trial.
If we decide to grant leave for further evidence to be called, and that means that we have to have an adjournment, what's the situation regarding costs?
Ma'am, the court can award costs against a legal representative under Section 19A of the Prosecution of Offences Act 1985, usually called wasted costs, and those are any costs incurred by a party as a result of any improper, unreasonable or negligent act or omission on the part of any representative or any employee of a representative. The omission that you might feel in this case is the fact that the issue wasn't raised at an earlier stage by the defence in accordance with their obligations to assist the court in active case management under the CPR.
Do you think have an adjournment? Do you think have an adjournment? Adjournment called in. We've no hesitation in granting an adjournment so that the Crown can call the officer. We also believe that the court can consider an order under Section 19A, and we would expect the Crown to prepare a schedule of costs wasted by what's happened here today, and to serve a copy on the court and on the defence 7 days before the resumed hearing, so that any representations as to the making of an order can take place at that hearing.